It's Wednesday afternoon and time for us to turn our attention to legal matters. This is part of our commitment to putting Southeast Texas first when we get to Ask the Judge. We are joined this afternoon by Judge Gordon Freeze from the 317th District Court, standing by there in his office at the courthouse. Judge, how are you?
I'm good. How about you, Jordan?
Doing well. Midweek here. We've got some interesting questions. This first one from a viewer who says, help, I have to move out of my apartment in 2 days because of a leasing dispute. 60 days ago, I went to the office and gave verbal notice of my intent to leave. The manager typed it into her computer. Several days later, I returned to the office and told them I may end up staying, and I asked about some options. The manager never provided those options. Well, today, I found out they rescinded my 60-day notice, and they told me if I leave now, I have to pay 2 months of rent. So technically, that is what's stated in my lease, but I want to know why my 60-day notice was not honored.
Jordan, I cannot stress this enough. Get it in writing, get it in writing, get it in writing. What they're going to end up with is a swearing match, and it's going to depend on her word versus the manager's. And the manager could very likely come in and say, well, hey, what I wrote down was my Amazon or Temu order. I think as the questioner said, they're going to be subject to the provisions of the lease as far as notice and termination. Likely what's contemplated in that lease is that it has to be in writing. So,
and just to be the devil's advocate, would that mean then the office manager should email back or initial something, or what exactly does in writing mean at this point?
You know, I would say if you're the tenant and you're trying to get out of that lease, I would always recommend sending an email or doing something in writing where you have confirmation that you can show I brought this to them or I sent this to them and I gave this notice on this date. And I think that's where the problem may lie here.
Okay, good to get some clarification there. This next question is from someone who says, years ago, I built a garage that slightly crosses onto my neighbor's property. They never said anything. It's been 15 years. Do I have any legal right to keep the structure where it is?
You know, I'm going to say what lawyers often say when you're asked questions like this. It depends. Similar to the last question, what I would recommend anytime you're going to build or add a structure on your property, I really think it's a prudent investment to get some type of a survey done. This will give you clear notice of what your property lines are, where you can and can't build, and can really prevent you from having title issues when you go to sell your property. With that said, it sounds like they're admitting that they went over and built over those property lines. The good news is the fact that 15 years have passed, they may be able to fall under what's called adverse possession. If you have built or you possessed property that's not yours for a certain period of time, typically in Texas it's 10 years, but there's some other provisions that apply with that. If you've built and you've had open and obvious use of that property and the rightful owner has not objected, you have the opportunity to get that grandfathered in or be able to possess that property with that new property line. I would definitely recommend speaking to a very good qualified real estate lawyer about this as soon as possible, but I think they might be in good shape here.
Judge, we're going to have to leave it there. Very interesting stuff today. Like you say, it depends.
Unfortunately, that happens a lot.
We appreciate your time. Friends, if you've got questions for the judge, go to 12newsnow.com/askthejudge, and there's a form you can fill out right there.